Well, good morning on this beautiful September 13th morning. My name is Jim Reedy, and this is the New Hampshire Tech Alliance HR Exchange, sponsored by She and Finney. Just so grateful that you could be here. We're kicking off another program year, and this is the 2023, can you believe it, 24 program year, and we've got a lot of great presentations coming up this year. As you know, typically we start in September and we go all the way till June. The 1 month that we don't have programs is May, because that's when we do our annual employment law seminar. And but this month is I think a terrific program, which I'll get back to in a second. But in the meantime, a couple of housekeeping items. First of all, October's event, it's going to be navigating religious accommodations in the workplace. You know, there have been recent court decisions, but also guidance from the EEOC on that. And of course, many of you dealt with the issue of religious accommodations, especially during COVID, but it continues to be an issue in the workplace, and there are a lot of questions, and there's also a lot of misinformation out there. So Cassie Rogers will join us for that. And November 15th, issues to consider with a post-pandemic employee handbook reboot. What do we mean by that? What we mean is that oftentimes, especially in the last couple of years, things didn't have the same priority in the workplace. And one of the things that was not a priority perhaps was a update of your employee handbook. But with many changes in state and federal law and are just cultural changes in the workplace, it's time to consider. So we'll have that presentation as well. And then in December, we do our annual top 10 wage and hour violation list, which comes from our friends at the New Hampshire Department of Labor. And we also pepper in their information from the U.S. Department of Labor. A couple of other quick housekeeping items. The HR credits for this program will be available on one of the last slides of this presentation. But for those that don't catch that, Liz Tezik, of course, will be sending you an email with that code, with the PowerPoint itself, Dave's PowerPoint, with some articles that Dave thought would be helpful as well, and a recording so you can share with your friends. You know, who needs to go to the movies these days when you can watch a presentation like this over a box of wine? So, but with that, I will tell you that restrictive covenants are something that come up all the time in our practice and dealing with our clients. And the questions are these enforceable? When I hire somebody with these covenants or these restrictions, what should I be concerned with? Should I hire the person, and so on? And whether we're talking about non-competes, non-solicits, non-disclosure, or some combination of those, you know, oftentimes in a practice like ours, a firm like ours, you have people that we're not supposed to use the word specialized, but certainly we think that this is a go-to person. Dave McGrath, managing partner in our firm, litigator, and mediator, but great deal of experience dealing with restrictive covenants. And he's the person that many of us go to with questions like this. So I'm going to turn the program over to Dave. I know you're going to enjoy it. Dave, take it away.
Thank you, Jim. Good morning, everybody. There really is, as Jim alluded to, there's a lot of confusion about what a New Hampshire business can and cannot protect and how it should go about protecting legitimate interests that it has. In the relatively short period of time that we've got together, a little over an hour, there are really three things that I'd like to try to accomplish. One, I'd like to clear up common points of confusion in the area of restrictive covenants. Two, I'd like to explain good steps that businesses can take to protect important business interests in New Hampshire. And three, I'd like to answer whatever questions you might have. And with respect to the questions, I may, as we go along, you can see the Q&A at the bottom of your screen, I may handle some questions kind of midstream, but at the very end, I'll deal with whatever questions we have time for that remain. Okay. All right, let's get underway. Next slide, please. So there are lots of labels, and Jim mentioned a few of them. Restrictive covenants, non-competes, which is what folks typically think of, non-solicitations, non-interference, non-piracy, non-disclosure. Given all of these various labels, it's no wonder that not just business folks, but lawyers and even judges get confused about these terms. Sometimes they I think, mistakenly use them interchangeably when oftentimes they mean very different things. And so we're going to spend a little bit of time talking about the importance of proper labeling of these agreements, so that when we're discussing them, I don't just mean now today, but as you're, in your business and you're thinking about them, you're all talking about the same thing. Okay, next slide, please. When we think about non-compete agreements, which is what people typically think of, understand that in some sense, any kind of a restriction on an employee after the employee leaves your business is anti-competitive, in the sense that it is impeding that person's ability freely to compete. And so in some sense, it is anti-competitive. But that doesn't necessarily mean that it's non-competitive, right? Because the person could still compete in some ways, but is not entirely restricted from competing. So when I use the term non-compete, I'm really talking about a restrictive covenant or a restriction in an employment agreement that prevents that employee from competing entirely against the employer, usually within some geographic area, for some proscribed period of time, 6 months, 12 months, 18 months, something like that. Okay, so non-compete, as I use the term, should be thought of as something that is totally non-competitive, right? That cannot compete at all within a geographic area for some proscribed period of time. As I'll discuss a little bit later, in the state of New Hampshire, those type of agreements, purely non-competitive, non-compete type agreements, are almost never enforced. Okay, they're almost never enforced. At the very end of the talk today, I will talk about one exception to that, or two. But in the context of employment, there's really only one exception to that, and I'll talk about that a little bit later. So non-competes, straight non-competes, almost always unenforceable in the state of New Hampshire. And understand, and we'll talk about this a little bit more, that my discussion today with you folks is focused on New Hampshire law. And laws differ with respect to restrictive covenants quite a bit state to state. And even Massachusetts law is different in material ways than New Hampshire law, and so on. So today's focus is on New Hampshire law. So the preferred nomenclature, what I like to think of as the kind of the ideal umbrella term for these type of agreements, is restrictive covenant agreements, which when I'm running around the halls here, I refer to as RCAs, restrictive covenant agreements. And under these restrictive covenant agreements are various restrictions. For example, my next preferred label is a non-interference restriction. And I'll talk in the next slide, I think, about why I don't think the more commonly used non-solicit is an appropriate term, okay? So within the restrictive covenant agreement umbrella term falls the non-interference label. And that applies to customers and prospects and employees. And so when you're using a non-interference restriction, you're really talking about some provision that prevents a former employee from utilizing the goodwill that resides in that employee, right, to take or to try to take customers and prospects or employees for some period of time, okay? And in the state of New Hampshire, if they're properly drawn and properly implemented, those type of restrictions are enforceable, okay, are. And then the second preferred term, non-disclosure restrictions. And non-disclosure covenants protect your information. Okay, we do have trade secret statutes and laws that also protect your information, but you can further protect your information with non-disclosure restrictions. Okay, so when you think about non-disclosure restrictions, and you think about non-interference restrictions, these are all centered around protecting the company's, the business's legitimate business interests. And what are legitimate business interests? Well, one, the courts have made clear that a legitimate business interest that the employer can protect is goodwill. Goodwill that resides with customers, goodwill that resides with other employees. That's a protectable, legitimate interest. What else? The protection of proprietary and confidential information. That's also a legitimate business interest that's worthy of protection in the state of New Hampshire. What kind of things are not legitimate business interests? Well, trying to recoup training expenses, for example. Well, we spent a lot of money to train this person, and so we think they shouldn't be able to compete against us for some period of time. Not a legitimate business interest in the state of New Hampshire. And oftentimes, businesses just don't want some employee who may be particularly good at their job to be out there competing against. There is no legitimate business interest underlying that kind of a restriction. And so it's not surprising that that kind of blanket prohibition against competition is unenforceable in New Hampshire. Okay, next slide, please. All right, let's take a closer look at non-interference restrictions, not as they apply to employees, but as they apply to customers and prospects. Oftentimes, I'll see an employment restriction from a business client, and it'll prevent the outgoing employee from doing business with, for some period of time, all of the company's customers. Okay? But if you go back to the principle of legitimate business interests, what's the legitimate business interest in preventing an employee from doing business with all of the business's customers? There really isn't one. It's too broad a restriction, almost certainly. Because, for example, let's take the legitimate business interest of goodwill. If goodwill is the legitimate business interest, it really isn't possible for that outgoing employee to have goodwill residing in them with some customer that they've never interacted with. Right? So if they've never met that person, they've never had meaningful contact with that person, there can't really be any goodwill. So what other legitimate business interests might support that kind of a restriction? Well, we've already talked about that. That's the protection of information. Okay, so maybe there's some employee who has not interacted with customers such that there's not goodwill, but they've seen a whole bunch of sensitive information, maybe even about a customer, their pricing preferences and so forth. If that's the case, then a restriction against that employee for those customers about whom they've gained some real substantial information can be enforceable in the state of New Hampshire. And that's why in this slide, you'll see they can't accept business from those customers and prospects that they've interacted with. That's the goodwill part, or about whom they've learned some kind of proprietary confidential information. Okay. All right, why is solicitation? I said just a minute ago, I'd tell you why I think solicitation, which is very commonly used, is not the right concept to be thinking about. And that is that I think that in most people's minds, solicitation connotes some type of active initiation of contact, right? So if you've solicited some customer, you've called them up, you've tried to get their business, or if you're dealing with an employee, you've contacted them to try to lure them away. But really, what we're talking about is a restriction that prevents them from capitalizing on the goodwill that's residing in them for some period of time. And that means that it applies even if the customer, for example, has contacted the former employee, right? So it shouldn't matter whether the employee reaches out to the customer or the customer reaches out to the employee. Again, in the state of New Hampshire, they should be just prohibited from capitalizing on that goodwill. So because solicitation connotes some type of active initiation of contact by the former employee, I think it's the wrong concept. Whereas if you think about it in terms of the non-interference label, they can't interfere. And whether the customer contacts that former employee or the former employee contacts that customer, either way, they're interfering in that relationship by utilizing the goodwill that's residing in them, and that's prohibited for some period of time. Okay? What's the reasonable period of time? Well, there's no exact amount of time that is set in these agreements and restrictions. Typically these days, we think about, in a non-interference provision, we think about 12 months, sometimes 18 months, occasionally 24 months, but not typically. And the case law instructs us that it really, when you're dealing with goodwill at least, it's the amount of time necessary to kind of transfer the goodwill that was residing in Susan, over to Mary, who's still employed with you. And it can depend on a whole host of circumstances, factual circumstances. You could have renewals, and how often and frequently are the renewal intervals, and that kind of thing that can help to shape whether the restriction ought to be 6 months, 12 months, 18 months. But we very, very rarely see any kind of a restriction like this go beyond 24 months. Okay. All right. Next slide, please. Okay. A lot of this we've kind of alluded to, but non-interference restrictions as they apply to employees. I've already explained why the solicitation concept is a wrong concept. Applies equally well to the employee side of things as it does to the customer side of things. And it is true that courts will be a little less scrutinizing when you're dealing with employee non-solicitation type restrictions, which is to say non-interference restrictions. They'll be a little less scrutinizing, but they still will scrutinize these restrictions. And so employers still need to craft them narrowly and reasonably. So here, it isn't enough just to prevent the former employee from reaching out and initiating contact with your current employees. So instead, we draft these restrictions in New Hampshire to prevent that former employee from hiring, from helping others to hire, from encouraging even or inducing in any way your current employees to leave you. Okay, so they're pretty broadly written, and those type of restrictions will be enforced again for that same temporal period, 12 months, 18 months, something like that. Okay. All right, next slide, please. Non-disclosure restrictions. So we talked about legitimate business interests. We just focused a little bit on goodwill and the protection of goodwill, both as it applies to customers and as it applies to your employees. Now we're talking about the other legitimate business interest that's routinely recognized in the state of New Hampshire as protectable, and that's your information, your sensitive proprietary information, often referred to as a non-disclosure restriction. So just to back up a little bit, we've got the restrictive covenant agreement under which we have a non-interference provision. Section 1 of that non-interference provision deals with your customers and prospects. By the way, prospects have got to be kind of hot prospects, not just everybody in the phone book. Section 2 of the restrictive covenant agreement is going to have a non-disclosure restriction, okay, that protects your information. And that provision will prevent the former employee from disclosing, sharing, or using in any way the company's confidential information. What is confidential information? It's anything that's really of value to the company that is not public or is not readily attainable through public channels. Financial information, technical information, procedures and processes by which you do business, strategic information, all of those kind of things are worthy of protection. And what isn't confidential information? Well, I've already implied it. It is the stuff that is available publicly, readily available publicly. Okay. And a trade secret is just as a law in the state legislation in the state. It's a statute that also protects companies' proprietary information, even if you don't have an agreement. It also provides different remedies to an employer other than just, say, breach of contract in the event that somebody, a former employee, were to breach their non-disclosure restriction in an agreement. I'm not going to get into a lot of detail here about trade secrets. Understand that they're a little harder to satisfy. Okay, so the courts scrutinize whether or not, for example, companies have taken all appropriate steps and reasonable steps to protect information. And if they haven't, even if it's otherwise proprietary and confidential stuff, the court will not find that that's a trade secret. So the employer needs to take reasonable steps. It could be audits, making sure that you have good agreements in place and that sort of thing. Okay, it's just another vehicle by which employers can protect their information. Okay, next slide, please. Okay, there are certain situations that arise that the legislature has determined are special circumstances. And this is one of those circumstances. That is when we're dealing with low-wage workers. What is a low-wage worker? A low-wage worker is, think about it as somebody who is earning not more than 2 times the federal minimum wage. So I tend to think about it, anybody that's $15 an hour or under is a low-wage worker. And the law went into effect in 2019. So what I'm about to tell you applies to those agreements that were in place from that date. I think it was in September of 2019 forward, but not to agreements that were in place prior to 2019, unless, it's always an unless in the law, unless there's a renewal clause. If you have one of those types of agreements that gets renewed every year, then that's different, okay? But when you're dealing with an agreement that would otherwise fall within the ambit of this new law from 2019, any kind of a restriction really that would prevent that employee from going out and competing with the company is invalid. Couple of exceptions, we think. And I say we think because this hasn't all been tested through decisions by the New Hampshire Supreme Court yet, but I feel highly confident that if you're dealing with non-disclosure restrictions with a low-wage worker, you can't use or share confidential proprietary information. I think that's going to fall outside of this law and be enforceable. Or 2, you can't capitalize on the goodwill that you have with other employees and raid us, for example, then that's probably going to be enforceable too. But a straight non-compete, which frankly wouldn't be enforceable anyway in almost all circumstances, even if you're not dealing with a low-wage worker. But even the non-interference restrictions that we talked about, as they apply to customers and prospects, not going to be enforced almost certainly against a low-wage worker, okay? And if you take a step back on that and you think about it, and you think about the principle of legitimate business interests that really undergirds this entire area of the law, it makes some sense that those type of restrictions would not be enforceable against a low-wage worker, because in most circumstances, a low-wage worker is not going to have meaningful contact with customers such that there's valuable goodwill residing in them with those particular customers. I hope that makes sense to folks. Okay, next slide, please. I don't know if any of you are medical providers, but we also have a law that went into effect in summer of 2016 that essentially prohibits any kind of a restriction against physicians, okay? any kind of a restriction that would prohibit them, impede them even from treating patients is going to be invalid and unenforceable in the state of New Hampshire. They have their own confidentiality obligations, obviously, as physicians, but those type of non-disclosure covenants almost certainly not part of this law. But any other kind of restrictions similar to what we just talked about with low-wage workers, not going to apply to physicians. Keep in mind that this law applies to physicians. It's not meant to apply to other medical providers like nurses or dentists, for example. This is just physician specific. And just like in the case with low-wage workers with 2019, here, same applies, but with respect to 2016. So an agreement in place prior to 2016 that does not get renewed, not going to be subject to this. May not be enforced anyway. Court may decide, exercising its own equity powers, not to enforce it, regardless of whether the law applies. That's a different matter entirely. Okay, next slide, please. We've talked about the proper labeling of these agreements and these restrictions. We've talked about the interests that are worthy of protection. And we've talked about the limits of the type of restriction, okay, both temporally, the amount of time, and also the scope of those restrictions. Can't, for example, cannot apply to all your customers, but they can apply to those customers with whom the person has interacted or about whom they've gained significant information. All right, what's next? What's next is you've got to make sure that you implement it all properly. Because if there's a misstep here, all of your good work before is for naught. Okay, so it's essential that businesses and companies implement these agreements properly. All right. And the first part of that centers around notification. Okay? You've got to notify the employees that these type of restrictions are going to be expected of them. So when do you present it to them? And that we know the answer to very clearly because it's set forth in a statute. You need to make sure that you give new employees, incoming employees, onboarding employees, a copy of the agreement before they accept the job offer. Okay, if you give it to them after they've accepted the job offer, it's invalid. Okay, so you've got to give it to them before they accept the job offer. Strong recommendation, just attach it as a matter of course and practice to the offer letter. Okay, in your offer letter, you'll say this is a condition of employment. Attached as Exhibit A is the whatever restrictive covenant agreement. So you give it to them, a copy of it with the offer letter. You also make sure that they sign it and get it back to you before they commence employment. Okay, those are the two most important things. And again, we're talking about new employees. Okay? It's a little different when you're dealing with existing employees. Some clever, crafty folks may be thinking, okay, so the law requires us to give it to new employees before they accept the job offer. And I'm telling you now, it does not, that law, apply to existing employees. It doesn't. It only applies to incoming employees. So it may seem as if, well, if you miss that, you botch it in some way, and now the person is on board and they haven't signed the agreement, no problem. You just give it to them a week later and say, now you're an existing employee, that law doesn't apply. The problem with that clever approach is that there's a principle of fairness that the court imposes on this entire area of the law, okay? Fairness. So if the court determines that the employer has been unfair, has acted in bad faith in some way, then the court will not enforce not just that restriction, but may even refuse to enforce any of the restrictions in the employment agreement, even those that would be otherwise valid. Okay, so keep in mind the obligation always to treat the employees fairly, particularly as it applies to these agreements. So what do you do with existing employees? Let's say that you've got a group of existing employees who have not signed restrictive covenant agreements because maybe the employer, the business hadn't required them before, but now wants to. You can do that. You can do that. And in New Hampshire, just continued employment is enough what we call consideration. It's enough of an exchange of benefit to the employee. So it can be done, but again, fairness would dictate how you treat with that. So you present those agreements to the existing employees. You'd give them ample opportunity to get it reviewed. You'd probably, in some written document, encourage them to get their own lawyers to help them review it, revise them so that they understand it, right? All of this to be used later. If somebody challenges the enforceability of it, I want to be able, as the business's lawyer, to walk into court and tell the court and demonstrate to the court that the employer has been fair, right? Been fair and given the employee full opportunity to understand it. We were not trying to do anything underhanded here. And so, fairness. Next slide, please. Okay, so sometimes employers ask me, who should get these agreements? And should we give them just to everybody? And the answer to that, I think we all know by now, is no, everybody shouldn't get them. Well, we know for sure that low-wage workers shouldn't be getting them, or at least they shouldn't be getting ones that have anything more than a non-disclosure, protection of confidential information, possibly a non-interference of employee restriction, right? So that's, you want to make sure, and again, if you step back and think about the legitimate business interests, then that'll help guide you. If you're trying to protect goodwill, I mean, your sales team is going to get one version of this, and some support staff that don't interact with customers may get just the confidentiality type of a NDA, non-disclosure agreement, and so forth. I talked earlier about the one exception on the straight non-compete, the blanket non-compete. I'm going to talk a little bit about that right now. When you have a very highly positioned executive, and that person has access to all of the most secret information that the business has. There is a case in the state of New Hampshire where the Supreme Court has upheld a straight non-compete, but only under a circumstance where that employee was also given substantial severance. So they were essentially sitting on the sidelines, right? They couldn't compete at all within a very narrow niche market, which was also a relevant factor. And they were paid for a whole year while they sat on the sideline. So I just point this out because if you've got some very high-ranking executive, then there may be some opportunity for enforcement of a straight non-compete for a limited duration, depending on the circumstances. But otherwise, in the state of New Hampshire, employers should be thinking just about the type of non-interference restrictions we mentioned earlier. Okay, next slide, please. Okay, some more special situations. Talked about low-wage workers, talked about physicians, and just now talked about non-competes as they apply to high-level executives. That's, I think, the third bullet point there. There's some other situations. One is that when you're talking about restrictions, post-employment restrictions that are tied to some special consideration, right? So let's think about that as some type of an equity agreement. Got some type of an incentive equity program at the company, and you've got a 6-month non-compete, perhaps, that's tied to this special equity program. It's possible in the state of New Hampshire that that type of a restriction that's tied to that type of special consideration could be enforced, okay? As long as it's not a condition of employment, right? So what we've been talking about typically are these type of restrictive covenant agreements that are a condition of employment. You don't sign it, you can't work here, right? So you can imagine a situation where you maybe have 2 agreements. One is that kind of typical restrictive covenant agreement that I've been discussing. Then you roll out a special equity program, and maybe you have a different restriction tied to that. It's entirely optional. They can opt in or they cannot opt in, and it doesn't affect their standing at the company at all. So those type of circumstances are different, or at least potentially different. The other is just in the context of the sale of a business. Sometimes 2 businesses, right? There's a combination of businesses, there's a merger or an acquisition or something. And there are non-compete restrictions and other restrictions that are attendant to that sale of a business. Understand that all of what I'm discussing today does not relate to that context, does not relate to these restrictions as they apply to the sale or sales of businesses, okay? Only that which arises out of the employment relationship, okay? All right. Next is post-employment severance agreements. So if you have some employee who's been asked to leave, as an example, and you've presented that employee with a severance agreement, their employment relationship is ended, and now you've given them a severance agreement, and they've got oftentimes 21 days to consider it and think about it and get counsel about it. And maybe in that severance agreement, you have a restrictive covenant of some type, okay? You may even have some non-compete restriction in it. That too is going to be looked at differently by a court. Doesn't mean that the court's necessarily going to enforce it, but the court's going to analyze it a little differently because it was not a condition of employment. In fact, it all arose after the employment relationship ended, right? So if for the first time this type of a restriction shows up in a post-employment severance agreement, understand that it may be looked at differently. There's an exception to that because there's oftentimes exceptions in the law, and that is that if the severance agreement itself and the right to severance was negotiated at the inception of the employment relationship, probably going to be looked at more similarly to what we've been discussing all along, okay? But if it was not a condition of employment at the outset, but instead arose entirely after the employment relationship ended, and it's just part of a separation agreement that the former employee can either accept or reject, then I think it's going to be looked at in a more relaxed way by the court. I want to point out right here one potential problem, a real trap for employers, and I've seen it a couple of times, and it's worrisome. Severance agreements that businesses and companies use all the time have what we lawyers call an integration clause in them. And all that is a provision that says, hey, any other agreement that we may have had in the past is extinguished by this agreement, okay? And this agreement is the only agreement that we have between us, okay? That's a useful provision to have in agreements and contracts, and it's almost always there. The problem is that if you have a restrictive covenant agreement that of course is intended to survive for some period of time, 12 months, 18 months, maybe 24 months, as we talked about earlier. You cannot be extinguishing that inadvertently through this integration clause. Okay. So first of all, that's why it's important to have your lawyers looking at your severance agreements, because they spot things like this. But it's easy enough to cure. And what you do is you just accept it right in the separation agreement. Accept the restrictive covenant agreement signed on or about this date, comma, and then you're fine. You may even attach it as a copy to the severance agreement, making it clear that it's intended to survive the signing of the severance agreement. Okay, I hope that's clear to folks. All right, jurisdictional and venue provisions and considerations. Started out this morning talking about how laws can be very different state to state. Absolutely the case. For example, the non-compete law in Florida, very employer friendly. Okay, very employer friendly. So straight non-compete provisions that would not be enforced in New Hampshire, and even those that would not be enforced in Massachusetts, would be enforced in Florida, just as an example. Okay. So sometimes, and this is something that particularly multi-state businesses ought to be thinking about. If you've got a business that has employees in various states, including those that are working remotely, then understand that you may be able to impose New Hampshire law on those employees. You may not be able to. It's going to depend on which jurisdiction they're in, which state they're in. It may also be that with respect to one or more employees, the state that they're in is more favorable to the employer, to your business, than New Hampshire. And so you could, in that agreement, make that state's law govern the restrictive covenants. Okay, you can't just choose some state that doesn't have anything to do with the employment relationship. Let's say you've got an employee in Connecticut and you're a New Hampshire business. You can't pick Florida law to govern because you think Florida law is going to be better. It's got to have a reasonable and significant relationship to the employment. Okay, the person is performing significant services there, they reside there, your company headquarters are there, something like that. If there's some meaningful tie to the state, then you may be able to impose that state's law to govern the enforceability of the restrictions. And sometimes what we see, and increasingly so, are what we call kind of mandatory venue provisions. And these basically say all disputes of any kind arising out of employment have to be heard, let's say, to carry on my hypothetical, in the state of Florida. So now let's suppose that an former employee in New Hampshire runs into the New Hampshire court and says, hey, this wouldn't be enforced in New Hampshire. The court may look at that and say, it says Florida, it says this has to be decided down in Florida. And Florida seems like a reasonable place, given the nature of the relationship. You got to go down to Florida to have this heard. Okay. So there are some ways that employers thoughtfully and carefully might decide to use other jurisdictions and other states' laws to govern these restrictions, but it's got to be handled carefully. It's got to be handled by a lawyer. Okay, so if you're talking to your lawyer about your restrictive covenant agreements, you may just make note of the desire, particularly if you got a multi-state business. Should we be thinking about jurisdictional and venue issues? Okay. All right. New laws on the horizon. There's really one law that I just wanted to mention because it got a lot of press, and that was the Federal Trade Commission proposed rule on non-competes. And I'm sure many of you heard about it. On our website, we've written one article about it. Understand that it's in the rulemaking stage, and so it is not law, may never become law. It's certainly going to extend, rulemaking process is going to extend well into 2024. And for all the press it's been getting, when I distill it, at least as it applies to New Hampshire, it's really of no big moment for New Hampshire businesses. Okay, not just because it's some, at best, going to be law in the distance or rule in the distance, but it really only serves to prohibit those non-compete restrictions that prevent or preclude somebody from working for a competitor. Prevent or preclude, right? It doesn't say that it applies to those restrictions that don't prevent, don't prohibit, don't preclude, but only impede, right? Or bridge person's right, which is exactly what we've kind of been talking about all along. If you're dealing with a non-interference restriction that allows that person to work for a competitor, allows that person to work for a competitor for new customers, just prevents or impedes them from competing by prohibiting them from doing business with a subset of customers with whom they've interacted in the past, such that there's goodwill between them, or from capitalizing on confidential information in their head. That doesn't prevent them from working for a competitor. And so this FTC proposed rule, even if it goes into effect, is not really going to change the landscape in New Hampshire. So for all its press, as it applies at least in New Hampshire, not much there, in my view. Okay, I think that covers it. Questions? There's a lot of information there in a relatively short period of time. Okay, I hope this was helpful to everybody, and have a nice day.